Good afternoon, Dr. Depti. Good morning, Michael. Can you hear me?
Good afternoon.
Okay. Thank you for joining us today, Dr. C. Michael, you can unmute yourself.
Yes,
Let's
I can hear you.
a little icebreaker before the mentorship.
Okay, I can hear you. I can hear you.
How are you doing?
Yes, I'm fine. I'm fine. Thank you.
Okay. Good morning, Miss Juliana.
Hello, Hussein. Thank you so much. How are you doing? Thank you, Deputy. Thank you, Michael. Hi, Deputy. Hi, Michael. Hi, Joseph.
Good morning, Miss Juliana. Good morning, Deputy.
Thank you.
Okay, good morning, everybody. Good afternoon, Dr. Depti. My name is Hussein Mahadi, and I'm the moderator for today's session on patent drafting. Today is the third week at the JIIPCC mentorship and internship program. And for patent drafting today, our topic is preparing patent application, part of patent application and patent drafting. We are supposed to have 3 mentors, but we have 1 mentor with us now, and we are expecting 2 mentors. Our mentors for today are Dr. Depti Malhotra, Rakesh Sharma, and Amit Valid. So quickly before our mentors join us for today, I will be sharing some announcements and also telling us what the program is all about. So JIIPCC Mentorship and Internship Program is a quarter program for young professional students and students across Africa. And these are afforded opportunities to access advice, mentorship, internship, discussion forums, industry updates, and resource experience mentors. The program encourage continuous training, development, and evolution in Nigeria, Africa, and around the world. I don't know, can we all hear me? Can we hear this?
Yes, I can hear you from my end. I can.
Okay. So objectives of the program are to provide easy access, guidance, training, and resource materials for and young professionals, to facilitate dialogue and network among experienced and less experienced professionals, to transform mentees into mentors, and to facilitate further mentorship, internship, scholarship, and job placement for the mentee. So that's what JIIPCC is all about. For those joining us for the first time, I'll be reading some announcements. The 2 major announcements we have for today is the registration for the next quarter, which is 2023. JIIPCC program is currently ongoing. The registration is ongoing, and you can share the link with your friends and colleagues that are interested in any of the areas of courses that we have: drafting, health tech and law, fintech, the energy industry, artificial intelligence, and intellectual property. And the final announcement for today is that the JIIPCC get-together party, registration for the JIIPCC get-together party is currently ongoing. We are all advised, we are all
Sorry, please, can we still hear Hussein? Okay, I think he's not here. Maybe he's having network issues. So
Yes.
let's go into the presentation. Michael, please, you can start your presentation. Thank you.
Okay. Good morning once again. Good afternoon, Dipti. Um, Moderator Hussein was supposed to help me to share my screen. This one that he's not online now.
Okay, but is
I
it
don't know if
possible
we can
to
take some time
start
to wait for him.
presenting first? Can you start presenting without this slide?
Okay, yes, I can.
Okay,
Yes,
thank you.
I can. I can.
Okay.
Okay. Of the patent application and then provisional patent drafting. The first is a first step toward obtaining a patent that sets out clearly the scope of legal protection granted to the patent owner. Now, a patent application, like from the first week, I've a little bit touched this area, but I'll still bring it up again. A patent application typically contains three parts. We have a request, and in some countries, the request is also known as an application form. And then secondly, we have the description, and the description can come up or is a compulsory aspect of patent preparing patent application, and it also suggests that under the description, one or more claims could be added to it, and then one or more technical drawings concerning the invention for proper understanding should also be highlighted there. And then lastly is abstract. Now, a patent drafter who seeks to prepare patent application should just note the following points, should have it abreast in his heart or her heart, as the case may be. Now, a patent drafter should obtain disclosures about the invention to be patented from the inventors. I don't know if we can all hear me.
Yes, we can. We can hear you.
Okay, thank you. So the patent drafter should obtain disclosures about the invention to be patented from the inventors. Now, the patent drafter will need to gather technical information and ideas about the invention from the inventor. This is a very, very key a key aspect in preparing patent application, because unknown to the patent drafter, the invention might be something that is out of his horizon, out of his scope of understanding. So they will need ample time to understand the invention. Now, the technical information should mainly be provided in writing, such as sketches, technical drawing, just like I mentioned under the requirements, the part of the content of patent application under description. I mentioned something like technical drawings, sketches, manuscripts, laboratory reports, papers, prototypes, and so on and so forth. Now, in line with this, a patent drafter should be able to key the applicants, that's the inventors, some key questions, because in my study of this little topic I'm presenting, I discovered that there's what we call NDA, and an NDA is a non-disclosure agreement. So if an applicant or an inventor meets a patent drafter and then he comes along with his or her representatives, it is very important that an agreement that is called a non-disclosure agreement be present, so that whatever is being discussed between the patent drafter and the applicant and their representative will only be binding on them. It should not be taken outside. Secondly, in preparing patent application, the patent drafter should note this second point. The patent drafter should be able to identify patentable inventions. Now, of course, not all claims are inventions. Some of them are just mere innovations. A patent drafter should be able to direct and channel their focus on patentable invention. Now, an understanding of prior art, that's existing documents relating to what the inventor is trying to invent or has invented, so to say. An understanding of prior art will help the patent drafter to determine whether an invention is patentable or not. So number 3, the patent drafter should understand the invention. Now, the patent drafter should not try to become the inventor. In such a case, you might want to be tempted to want to become an inventor. You are not the inventor as a patent drafter. You are not the inventor. You are just a patent drafter that needs to understand the scope and the analysis of the invention that is being given to you by the inventor. Now, understanding the invention also means that a patent drafter is able to prepare an application that discloses possibly patentable aspects of the invention, so that anyone that is skilled in that area can demonstrate its inventorship. Now, a patent drafter should, before filing a patent application, should be able to ask their clients who is or are the inventor or inventors, as the case may be. In some countries, it is customary practice that it is customary practice that you list all members of a research team as joint inventors. I don't know, as today training goes, maybe this point I would like that our mentors will explain it to me. That it is a customary practice that patent drafter should be able to list joint members of a research team of an invention, regardless of the degree of individual contribution to the invention. The next one is the parts of the patent application. The next slide, parts of the patent application. Now, the parts of the patent application typically contains the following: a request, a description, and claims, drawings, and then abstract. Now, what is a request? A request states that an inventor, that's an applicant, seeks to protect patent protection and is signed by the applicant or representatives. Just like I said while I was explaining the first point under preparing patent application, I mentioned something like the second point. I mentioned something like NDA, that's non-disclosure agreement. Sometimes inventors or applicants come with their representatives. Now, the request form generally contains aspects such as the title of the invention. Secondly, the names and address of the applicants and their representative, if possible, then an indication of the inventor, and then information relating to the priority claim, such as the application number and filing date of the earlier application on which the priority claim is based. Now, the next one is the description. Now, a description discloses the invention in detail, sufficiently clearly and completely, to the extent that a person that is skilled in the act will be able to carry out the claimed invention. This is somewhat like industrial. Your invention should be industrially applicable, because your invention is for the benefit of the country where you come from, and if possible, the world at large. So if people are not able to understand your invention, then I don't see what is the purpose of invention. Okay, the description usually contains several sections, such as the title of the invention, the technical field to which the invention relates, the background art in the field of the invention, then the summary of the invention, Then proper drawings and specific sketches. Like I said, this falls under description because it in patent drafting application, proper drawings in describing more about the invention is a priority. Finally, the invention embodiments. This simply talks about examples. And finally, the description discloses greater detail of the claimed invention by way of examples, just like we have seen in our week 1, week 2, how our mentors gave us examples, typical diagrams showing examples of invention and modifications of things that are already existing, okay? And then for reference purposes, drawings are also very, very good. I don't know if you are still following me.
We are following.
All right. The next slide is claims. Now, the claims defines the scope of the patent protection of the technical features of the invention. Of course, invention has features, and then claims gives more light about the patent protection relating to the features of that invention. And clearly, claims are written in a particular format. I don't know if this format is a standard and acceptable format for all invention. I will need more clarity on that as today's session progresses. Now, for example, an apparatus comprising a pencil having elongated structure, including 2 ends and a center between the ends, an eraser attached to one end of the pencil, and then a light attached to the center of the pencil. That's just a little bit I know about claims. Then drawings. Now, drawings provides visual support in describing the invention and often facilitates better understanding of the claimed invention. It may include figures, tables, flowcharts, diagrams. So, like I said, drawings make people understand more about the invention. Then finally is the abstract. Now, an abstract is like a summary of the invention, limited to a certain number of words, as the case may be. It typically includes key features recited in the claims and is helpful for patent readers and readers of patent and documents. And then finally, the last slide is provisional patent drafting. Now, a provisional patent application discloses the invention, but it does not need to include patent claims. And then lastly, a provisional patent application will expire 1 year, after its filing date and effectively serves as a placeholder if a regular utility patent application is filed within that year. Just like one of the key points of provisional patent draft is like a placeholder of your original work. So I want to say thank you for the opportunity once again that is given to me by my mentors and facilitator, Miss Juliana and then Hussein. Thank you so much.
Thank you so much, John. Can we all hear me?
Yes, we can hear you. Well done, John.
Okay, thank you very much, John. So, I don't know if the second presenter is the second mentee for today. Okay, I just checked and I can see he's not with us. I think he was traveling, so he said he's on the road and he can't join us. So sorry for that. We'll be calling on our mentors to make their contributions.
Please, you can go ahead to read out their profiles first. Thank you.
Okay, the mentors' profiles for today. Okay. Hold on while I share my screen. Okay, I start with Mr. Amit Balib. Amit Balib is a mechanical engineer, LLB, pursuing qualified Indian patent prosecutor. Thank you for joining us today. And our second mentor is Dr. Deputy Malhotra. Is an expertise in Indian and global intellectual property rights, IPR, consulting, drafting, evaluation and management, and working as an independent consultant and technical expert for clients across the world. Also engaged as an IP expert and a CDL tutor. JIIPCC experience in comprehending and scientific, academic, and technical factors with the legal and commercial aspect of IPR practice and management. A registered Indian patent agent who works as an patent engineer and technology expert, biology, chemistry, pharmacology, bioinformatics, environmental science, toxicology, and clinical science in Indian and global IPR matters. A lawyer with an LLP from the Faculty of Law at the University of Delhi, specializing in IP, IT, international business, and commercial law. Previously experienced as a teacher and mentor under the Tech for Indian Fellowship, experience in developing course and course study materials, as well as teaching and mentoring undergraduates and university students. Proficient, prolific author, content creator, and editor with expertise in academic, technical, and legal writing. Published and grantsman. Excellent communication skills, both in oral and written, ability to work and under pressure with the proficiency and success, excellent IT skills. An avid believer in the philosophy of Dr. Seuss. The more that you read, the more things you will know. The more you learn, the more place you will go. Thank you very much for joining us today, Dr. Deputy Malhotra. Your profile is very amazing. So finally, I'll be reading the profile of Mr. Rakesh Sharma. Can you all hear me, please?
Yes.
Okay.
Yes, we can.
Rakesh is having a thorough and motivated career spanning nearly in patent analytics, drafting, and prosecution for US and EP jurisdiction. He worked very closely with engineering teams and supported their portfolios from idea incubation to innovation management. Mr. Rakesh, excellent understanding of law, claim, interpretation, and drafting skill. As a seasoned professional, he is readily engaged with various end-to-end IP services at different levels and provide intelligent IP solutions. He emphasizes more on promoting innovations for a better world. He loves drafting, patent claim, keeping all the infringement perspectives in mind. Furthermore, he has a strong bent of mind towards IP automation, knowledge on various IP tools and techniques, and can be used for either improving quality of IP or increasing the overall productivity. He's also an excellent mentor and possesses all the leadership qualities required for a successful IP professional. Thank you for always joining us, Mr. Sharma. So the first mentor that will be taking us will be Dr. EP, Dr. Deputy Malhotra. Please, you can unmute yourself and start.
Good afternoon, good morning, everyone. Can you hear me?
Yes, we can hear you.
Excellent. May I be allowed to share my screen so that I can provide my presentation?
Yes.
Is it visible? Yes.
Yes.
Okay, perfect. All right. So thank you, Michael, for a wonderful presentation. And I'm sure we'll be discussing your doubts in the coming session. So I shall start by talking about patent drafting and some of the requirements which are important from a pre-drafting plan. Because when you are drafting a patent, it is also very important to do your homework as a practice sheet. So some of the objectives that I'll be discussing in the presentation today is the pre-draft planning, which I believe is very important to secure better protection that may bring money, time, and effort saving in the long run. Can you hear me?
Yes, we can hear you, ma'am.
Okay. So
Yes, we can.
perfect. Thank you. So some of the important things that you may want to take into consideration, whether you're an inventor, an applicant, or a practitioner helping an applicant as a representative, is that you have to think, if you are going for protection of your invention in multiple jurisdictions, what may be the patentability requirements. So in addition to some of the things that Michael touched upon, like the requirement of novelty and utility and non-obviousness or inventive step, there are certain other patentability requirements that one must keep in mind, which I'll be discussing a little. Then another thing that he touched upon is very important and is dependent on different jurisdiction, which is the non-patentable subject matter. So with that in mind, it may be important to look at different optional and multiple claim structures that you may want to include in your written disclosure. Another thing that may be important is if you are patenting an invention. So as a practitioner or even as an inventor, you may want to first check for the patentability of your invention by utilizing what are called paid and unpaid databases. And many of these unpaid databases are run by patent offices in various jurisdictions because of territorial legal IP rights. And one of the ones that I'll be discussing today a little bit is the Strasbourg Agreement. Then another important thing, especially coming from a genetic resource, biological material, intensive IP work, if the invention involves biological material, it may be very pertinent to look into some of the international applications and treaties. For example, the Budapest Treaty, and also when you are accessing, for example, coming from Asia or Africa, many times our biological material accessed by people from other jurisdictions. So that access and benefit sharing becomes very important. And also it's important to disclose the source and geographical origin of the biological material so that the people from whose local knowledge you are gaining benefit, they are given the requisite benefit. Okay, so the patentability requirements, which are important, which are touched upon for a patent, are the novelty requirement, or the invention should be new, which Michael kind of touched upon, as well as the technical advancement. That is that the invention that you are patenting should not be obvious to other people who are practicing in the specific field or art that you are trying to get an invention patented in. Another requirement which is important is that it must be original. So like he touched upon the inventorship aspect. So it must be created by the person claiming to be the inventor. So that originality requirement is very important to be thought about even at the pre-drafting stage, that you have the right inventors who are getting credit for it, or you have got you've got the okay from them to use as an applicant to use that invention for a grant of a patent. Another important aspect is the enablement requirement that he kind of touched upon as well, is that when you are going for a written description, it should be such that a person in the art who is equivalent to that person going for a grant of a patent, they have the ability to make and use that invention based on the written description or the enablement that you have provided in your disclosure. Utility is another thing which has to be thought of. That is, the invention must be useful at the end of the day. Very important aspect that one has to look into when we are going for multiple jurisdictions is that the statutory subject matter requirement. So based on the territorial law or the domestic law of a particular country, you may have to look into work with the practitioners in that particular jurisdiction to see what are non-patentable subject matter and what are patentable or allowable subject matter for that particular invention. That I'll also discuss a little bit in the further slides. Now, based on the jurisdiction, there are also various kinds or types of patents which may be allowable. For example, most of the jurisdictions allow what are called utility patents, which are commonly used for patenting a product or a process claim. Then there are design patents. For example, in the United States of America, they allow design patents, which is for the protection for a unique product design, whereas there are other kind of IP protections in other jurisdictions, which are equivalent to that. Then there are plant patents as well. Again, United States allows that, which specifically refer to the creation of new mutant or hybrid plants, whereas there are some sui generis law that are allowable in some other jurisdictions, like India allows. So the non-patentable subject matter, which are, like I said, are territorial and municipal or domestic enactment or acts or rules dependent, and may also have some influence from the court of law decisions. And most common non-patentable subject matter include you're trying to patent a discovery, a scientific theory, or mathematical methods, which would not be allowed. A non-functioning product, not allowed. Utility is very important. A scheme or rule or method of performing a mental task, not allowed. Informative presentations or business methods, not allowed to patent that. In many of the jurisdictions, medical or veterinary procedures on humans or animals as targets and methods are not allowable subject matter, which I'll discuss a little bit further. Then inventions which are frivolous or which claim for anything, obviously, which is contrary to established natural laws, like perpetual machines, they're not allowed. Primary or intended use or commercial exploitation of inventions where the idea is that it is contrary to public order or morality, or that causes serious prejudice to human, animal, plant life, or health, or the environment. In many jurisdictions, those kind of inventions are not allowed. Then a mere discovery of a scientific principle or the formulation of an abstract theory is again not allowed as a subject matter. In that sense, discovery, if it's a mere discovery of anything which is available in a natural environment, like a living thing or a non-living substance occurring in nature, it's a discovery, it's not an invention, so it is also not allowed as a subject matter for patent. Then there are literary, dramatic, musical works, artistic work of aesthetic creations that again are not allowed to be patented, whereas you have copyright protection for such kind of subject matter. Then again, mathematical methods and business methods, even computer programs per se or algorithms, they're also not allowable subject matter in most of the jurisdictions. Now, what is important even from the perspective of patentable subject matter, in addition to the patentability requirements, is very, very important as a drafter to structure your claim, format your claims in a way that is allowable in a particular jurisdiction or the particular patent office. Now, of these, product claims have the widest scopes. For example, this would be considered and I've given the reference, a product claim, which is claiming for a purified polypeptide. So here, what is underlined is called the part of the invention, which is novel inventive. So all the examinations would be with respect to this particular underlined subject matter being novel and inventive, and you will be defending your patent claims with respect to that. In addition to that, the other most commonly used structure of a claim is a process claim, where the protection not just extends to the method. For example, this is a method claim, method of virus detection, so anything which is following wherein forms the part of the actual invention, wherein primer is selected from nucleic acid having at least 80% identity. And again, here the underlying part would be what is called the novel and inventive part of the claim. We can discuss this more in our discussion. Now here in a process claim, the protection, like I said, extends to the product which is so obtained from the particular process. Now, there are also jurisdictional dependent limitations on the claims, which may be allowable in certain jurisdictions and may not be allowable in other jurisdictions. For example, a product by process claim, wherein instead of going for a process and then getting the protection on the product itself, you're going for a product which is received by a particular process. But then here you'll have to establish the novelty and inventive step of the product itself, in addition to the process being novel and inventive. Now, use claims or even second medical use claims, like for example, if you are using aspirin or you're using ibuprofen, which is used for generally used for pain reduction. If you found a new use for that particular drug, now in many jurisdictions, that kind of new use would not be allowed. But in something like at the EPO, the European Patent Office, such a second medical use may be allowable depending on the other requirements of patentability. So that is a format that may be useful to have if you are thinking as an inventor or an applicant or a practitioner to go into that jurisdiction, to have that as one of the embodiments of your claimed invention. Then method of treatment, most jurisdictions do not allow that, like I said, for humans and animals, but some of the major jurisdictions do allow that, like the United States of America, the USPTO, Australia. So that may be important for a drafter to take that into consideration if the applicant is interested in going into that jurisdiction, to have that as an optional claim structure, so that that can be important when they enter that particular national jurisdiction. Now, the second part, like I said, what is important as a practitioner or even as a drafter for an applicant, for an inventor, for you, is that you look into the patentability of the particular invention that you're going from. And for that, there are databases available where you can use those databases to do a search such that you are able to see if your particular invention is novel with respect to what is present in the art, what is present and published in the art, and whether it has a technical advancement. So would it be obvious, would it be a workshop model if a person was to look at it from that perspective of a person who is and could be considered an expert in the art that you are interested in. So there, what is generally encouraged is to go for a patentability search. And one of the tools that helps with that is the Strasbourg agreement, which concerns the international patent classification. And this agreement was concluded in 1971 and amended in 1979. It is open to all the states or the contracting parties or the nations or countries which are party to the Paris Convention, which is one of the oldest conventions for patentability and other IP protection. The Strasbourg Agreement establishes that the International Patent Classification, or IPC, that divides technology for your invention into 8 sections, with approximately 70,000 subdivisions. For example, for an invention which is in the life sciences realm, a key part of the patent process is the searching of published patent literature to find out if a genetic resource, for example, based invention, satisfies the legal test of patentability requirements, such as novelty and inventive step. What is also important for life sciences and applied chemistry based inventions is that the disclosure many a times would have a chemical structure formula, and that provides a visual representation of the content of the classification place. So that can also be looked into. So that is where they are introduced in the scheme of the classification with a limited number of classification entries when they are necessary for defining their scope, for interpreting the scope of the subordinate entries. So that can help you determine whether your invention may or may not be patentable with respect to novelty and inventive step, so that you have a good idea of going further, or if there may be any changes that may be required so as to make them novel and inventive. So the IPC serves as an instrument for the orderly arrangement of patent documents in order to facilitate you to access the technological and legal information which is contained therein. Now, the basis for the selection dissemination of information to all users of patent information is provided by the IPC. And very importantly, the basis that IPC provides is for investigating the state of the art in the given fields of technology, so that you can have a good idea of what may be taken as a concerning document or prior art by a particular patent office. So you have a good idea how to defend it and whether you would yourself be able to call it novel and inventive with respect to what is already present in the art as published material. And also, it might also help for the preparation of industrial property statistics, which in turn permit the assessment of technological development in the various areas. So in addition to assessing your own invention, you may be able to guide the inventor or the applicant as to what may be tweaked such that your invention really crosses that threshold of inventive step and novelty. So these kind of things are highly encouraged to do these kind of searches prior to even starting the drafting. So patentability search may go a long way in helping an inventor or an applicant in the long run. Another thing that is pertinent from, again, a biological invention perspective is the Budapest Treaty. Now, the Budapest Treaty is the treaty on international recognition of the deposit of microorganisms for the purposes of patented procedure, and it was concluded in 1977. Now, the main feature of the Budapest Treaty is that a contracting state that requires the deposit of microorganisms for the purpose of patent procedure must recognize, for such purposes, the deposit of microorganism with any international depository authority that is recognized under the Budapest Treaty, irrespective of whether that authority is within or outside the territory of such a said state or country. So in other words, it is a legal instrument for one-time registration of microorganisms that is recognized all around the world. So now, why is it important? Such disclosure is important because, as was said in the very first presentation, the disclosure of the invention is a requirement for the grant of patents. And normally it is done by the means of a written description or complete specification. However, as you may be able to imagine, that when an invention involves a microorganism which is not available to the public or uses it in the invention, the disclosure is not possible merely in writing, but can only be effected by the deposit with a specialized institution of a sample of the microorganism, and that is where the Budapest Treaty helps. So the Budapest Treaty in such cases provides that the deposit of a microorganism with any international depository authority suffices for the purpose of patent procedure before the national patent offices of all the contracting states and before any regional patent office such as ARIPO, EPO, and whatnot. Hence, pursuant to the Budapest Treaty, the aforesaid national or regional patent offices must recognize the deposit of a microorganism with any international depository authority, and it is no longer necessary to submit the microorganism to each and every national authority, but such procedures, such deposits must be done prior to drafting or alongside drafting of the invention, because you have to provide this information along with the source and geographical origin of the biological material which is used in your specification, in your written description or disclosure to the patent offices in the very first of the priority application, which is basically the earliest filing of the application for a grant of a patent. So these are some of the things that I wanted to talk about today. So back to you, the organizers. Thank you.
Thank you very much, Deputy, for that very detailed presentation on patent drafting, then also the laws and the regulations and everything that guide it. I think it's something that everyone who is listening and those who still listen should actually go back to listen to, because it's very detailed. Thank you so much, Dr. Deputy. Let's hear from the second mentor also. Okay, so we have Amit here. Please, let's hear from Amit.
Mr. Amit, please kindly unmute yourself. We can't hear you.
Okay, or we can also hear from Mr. Rekash if he's ready. Hi, Mr. Rekash. Yeah.
Hello, everyone. Hello, Juliana. And
See you.
Before starting, I would like to express my thanks and gratitude to Hussein and Juliana for this platform, and Michael and Deepti for this very valuable, for providing very valuable insights for patent drafting, be it terms of like very valuable about the inventorship and about the patentability and pre-draft plan from Deepti and Michael. Thanks for that. And I will be touching upon all these points which you have highlighted. We will be talking about today about the patent drafting. Prior to patent drafting, I will quickly give you an overview about the anatomy of a patent, because if you understand the anatomy clearly, you understand the, I would say, the complete picture, or you are able to see the broader picture, then only you will be able to understand the like the nitty-gritties of the patent, like what are the crucial points and how you have to take care of these. So we are talking about today, we are going to talk about two things. First is the anatomy of a patent, like what all different sections are there and which sections are critical and why. This is important because we are talking about the patent. Like patent is a like broader picture, but if we have to dissect the patent, the term patent, it has to be like dissected into these many terms. Like it includes title, technical field, background, summary, drawings for each and every jurisdiction. I'm not talking about only US or Europe or India, China, Japan. For every jurisdiction, you must have to like draft your patent by including all these bullet points. So we will be talking about these, and afterwards we have a like session for drafting ideas and what do's and don'ts we must have to keep in our mind while drafting a patent application, or if we are guiding someone, or if we are handling a client, so how we can guide someone. Am I audible properly?
Yes. Yes, sir.
Yes, yes, sir.
Sorry, we can't hear you, sir. Can anybody hear Mr. Rakesh?
No, I think he's having a
No.
technical issue.
Okay, so if Mr. Amit is with us, he can also contribute or comment on the presentations. I think we lost him too. So let's wait for, let's see. $60 seconds. Mr. Rakesh will join us. Okay, it's here.
Are you? Yeah, actually, sorry for the inconvenience due to like the instability in the network.
Yes.
Are you able to hear me now?
Yes, sir.
Okay, so today we are going
Yes,
to
we
talk
can.
about, okay, today we are going to talk about two things. First is to understand the anatomy of a patent, like what all different subsections are there and how and why these sections are important. So we will be talking about the drafting of a patent, but prior to drafting, we must have to understand the anatomy of a patent, because if we are going to draft a patent, how many sections are there and what we have to write there, we must have to understand that clearly. So this is, we call the anatomy of a patent, which includes like these many primary fields like title, technical field, background, summary, drawings, description, claims, and abstract. Claims are, I would say, the heart of a patent. These are very crucial. I will talk about these in detail after giving you a brief about the anatomy. But prior to like jumping directly to the claims, let's talk about all the other different parts of a patent invention. And we'll surely try to touch upon the points highlighted by Dr. Deepti and Michael as well about the common inventorship at the last. So talking about the title, so title of invention should be concise and clear. It should not be like any like giving a breaking news to somebody, or it should be indefinite. It should be clear and concise. And talking about the technical field, it should also be aligned with the subject matter, like what our invention is trying to achieve. If it is related to blockchain, cryptocurrency, or a printer, or sensing technology, or some kind of like mechanical invention, or electricity generation, so technical in field should also be aligned and should also be written in very clear manner. The next step is the background. This is very crucial. Many times while drafting a patent application, what people do, they try to disclose the novelty in the background section. So we must have to take care of that. And in the background, you must have to set the, like, you must have to learn how to identify the problems, and you just have to highlight the need of the invention. There is no need to disclose the solution, but you just need to disclose the problems, and disclose or write the problems in such a way that somebody should be able to understand that there is a need of some kind of solution to overcome all those problems. So while writing the background, you must always have all these questions in your mind, like what, which, where, how, why. If you are having questions, then only you will be able to write in very perfect manner. Summary, this is not very difficult. This is like technical advantages and mirror of the claims. And when we will talk about the claims, we will talk about summary at the same time immediately, because it will be only the a mirror language of claims, as well as it is highlighting some kind of technical advantages. And about technical advantages, I have mentioned you in our previous sessions also. Whenever we are going to file a patent, either it must be novel, or it is also must be providing some kind of technical advantages on the existing technology. So these are like, these pointers should be highlighted in the summary section. So drawings part is there. So drawings are just to illustrate the invention for understanding. For understanding to whom? Any person having ordinary skill in the art. We call it posita in the US terms. So drawings must be able to convey a complete storyline, how and why, like how our invention would be structured and why or how it will be functioning. So if it is able to like explain the complete storyline to a person having ordinary skill in the art, drawings will also be used as a support for during the prosecution or litigation also. So detailed description, these are also in line with the drawings. So detailed description should be written in such a way, it should explain the best mode. Like there would be multiple embodiments. For suppose you have an invention on baking a cake. So cake would be like giving the best results at some particular temperature or pressure and for some particular timings. So this could be treated as a best mode. There could be other embodiments also, like for early baking or post baking. So these should be written in such a manner that best mode should be there, multiple embodiments should also be there, and how anyone can use it should be explained in detailed description. And this is in line with the drawings. The most important part of a patent application is claims. So all of the, I would say the previous elements I have discussed, be it title, background, drawings, all would be revolving around the claims. Claims are the elements which are defining the boundary of the invention as per the law. So claims, why these are important? Because as per the law, whatever you are writing in your patent application, they will only evaluate or examine the claims. So based on the claims, your scope of the invention will be decided. Whatever written in the detailed description is immaterial, but whatever you are claiming, that is most important part of a patent application. So these should be handled very carefully. I will touch upon this after explaining this anatomy. The last part of this is abstract. Abstract is nothing but this is only the technical summary of the invention. Generally, this is like very easy to draft, and many jurisdictions are having some kind of like word limit, not exceeding 150 words. So you must have to take care of that. Otherwise, these are just the mirror language of the sometimes independent claims. So this is just, I was talking about the anatomy, title, technical field. Like a patent application includes all these fields like title, technical field, background, summary, drawings, description, claims, and abstract. So all these are necessary. I won't say like claims are important, so only with the help of claims only we can file a patent application. Whenever you are filing, as Michael has already discussed, for filing a patent, a request in particular format is required, but for drafting a patent, these all fields need to be captured. So from the anatomy part, I would like to jump upon the drafting ideas. Let me just. So for drafting a patent application, it is not very difficult, I would say, but few key important aspects are there, which I guess like Deepti has also mentioned, we must have to take care of, like the subject matter eligibility, what are patentable and non-patentable subject matters. We must have to take care of all those, and everything if like properly captured in the patentability report, then drafting becomes easier. So patentability, as Deepti has mentioned in the pre-drafting plan, is important. So if that is like due diligence for patentability is done with very carefully, so drafting becomes easier in understanding the technological landscape and existing prior arts, and it helps us in defining the scope of the claims for our own invention. And while drafting, we must have to understand the like how we are telling the complete story of the invention. Patent application is nothing, but it is just an art to communicate your idea or invention and how you are persuading for the potential infringers. And for telling a story, you must have to have a cast of characters. As we usually see in the movies, they try to give a basic plot in the beginning, then complete story begins, and at the end there is a climax. So in the same way, the prior art is the existing story or the plot. Then we must have to understand about the likely users of the technology, inventors, as Michael has said, if there is only one inventor or multiple inventors, how we have to take care of that. We will talk about this at the last section of this presentation. So talking about the story of the invention, as I had mentioned, the background should only touch upon these points, like what is the need of the R, what are the failures or the problems existing people or existing society is facing. Just need to highlight only those points. Like this is, I would say, the incomplete, but incomplete in that way, we just like do not rush behind or do not go behind telling the complete storyline in the background. Just tell the problems somebody is facing, and that's enough for the background section of the invention. Never try to say, or never in emotions try to provide the solution or the novel aspects of your invention in the background, because whatever you are writing, it will be used, like it can be or may be used against you during the prosecution or during the litigation. So whenever you are writing a background, try to keep it generic. But if you are having some specific problems your invention is going to solve, specify all those problems, but never try to highlight the solution in the background section. This is what maximum immature patent drafters make a mistake at this level. I have many case studies related to this. If somebody wants to hear all those case studies, they can directly contact me after this session. I will share all those case details with you. So the second one is after the background section is the well-written patent application. So well-written doesn't mean your writing or your the style of writing should be very unique or very excellent. The well-written should be implemented or should be interpreted as like whatever you are claiming, it should be reflected in the description part. Suppose you are claiming some kind of like writing material or some printing material or some like how to use or how to assemble a printer. So your specification should be talking about like the method of using a printer or method of assembling a printer. So it should go like that. So it should be disclosing the best way. It should be disclosing the invention in such a way that it should be narrow enough to avoid the prior art, but it should be broad enough to avoid the design around, so that no any third party should be able to use your invention and you are not able to generate royalty from them by saying that you are infringing on our patents. How we can do that, we will talk about this when we will be discussing the patent claims. So this is related to patent claims, the most important and critical aspect of a patent application. As Deepti has already touched upon what is patentable and what is not, and it depends on various jurisdictions where you are going to file your patent. How a patent claim reads, I will give you an overview of the format, parts of claim, transitional phrases, and independent and dependent claims. We are going to talk about these in detail now. So there are multiple types of claims. Depends on like every time you are going to file a patent application, it always depends on the nature of your invention. It is not necessary or statutory requirement from the patent office that you must have to file these many types of claim every time you are going to file a patent application. This is only dependent on the nature of your invention. For this, let me again give you one example. This is related to the claim diversity. Suppose for one patent application, one can like relate multiple inventions, provided all inventions are bound to same inventive concept. I will like to give you an example. Like these are multiple claim types and what is their importance, we will discuss there. So based on your nature of invention, you can file an apparatus claim if you have invented some kind of new apparatus. Suppose a printer, you have invented some kind of new printer which is printing very efficiently, very fast, very like quality is very high. So you are going to go after the apparatus claim. If you are like having a system, suppose there are two or multiple modules there, and by just using the mobile phone you are able to print from your printer, then it could be treated as a system claim. Method is there. Suppose printer is the same having existing hardware, but you have invented some kind of new software which helps you in like printing very fast and very I would say high efficiently, then method claim would be the only option for you. CRM is simple, like this is, we call it computer readable media or the storage. Some inventions which are in the like software form, which you have like some kind of algorithm which is in the software form, which somebody can install in their computer or mobile phone or any electronic device, and they are able to perform efficiently over the existing technology. So these are called CRM claims. So let's talk about this with some example. Your invention is related to Braille script printer. Braille script printer is nothing but a printer which helps in printing a Braille script for visually challenged people. So this is nothing but a Braille script printer. So in 5 different ways, you can cover your invention related to this printer. And what are these 5 different ways? The first one is a new machine, because a printer which is not printing only this similar, or I would say the normal 2D printing, it is printing something in 3D format. So in a new machine you can claim, because it is a new product. And if like invention is not only tied to the machine, but to the, I would say, the software also, or algorithm you are using, then a new process to operate a machine also, because sometimes it is only simpler to just insert the paper, press the printing button, and you are getting the print. If that is the case, then you are not entitled to get a patent on this. But if your process is also unique, you are also entitled to get a patent on how to operate that machine. See, what is the beauty of patents? Like, you are able to get a patent on machine, how you are making a machine, how you are operating a machine, then a new method to use the new product. Like how, or I would say a system claim this is, how we are generating the Braille script from a printer using a software. And the last but not the least is related to software we are installing in the that specific printer. Suppose all the existing printers in the market, by using only our software, they are also able to transform their normal printing into the Braille script printing, then your software is also equally important. So advantages of claiming is simple. Like it helps you in like printer in non-operational state. You can generate revenue from all those manufacturers who are manufacturing that printer. Either like you are making a new product or manufacturing, because this is the beauty of the patents. You are able to think from all the different perspectives how and why your invention is equally important. So coming back to the main slides, this was related to the types of claims, like how in how many ways you can nurture your idea, or you can take the maximum benefit from your idea by thinking from all different perspectives. This was just, I was trying to give you a demonstration. Coming back to the like types of claim, these are like the apparatus claims are there, method claims are there, system claims are there, computer implemented, or I would say the method, which I have already touched upon, Marcus, Jepson, and means plus function claims, which based on the like need to know basis, you will be able to understand. Otherwise, I will give a separate session on these separate types of claims. So right now, before like making it too complex, just try to understand the claim, what a patent claim means. So in very simple or layman terms, if I have to explain, a patent claim comprises only in 3, I would say, parts. I have color highlighted all these 3 parts. The first part, a writing apparatus, this we call it a preamble. The second one is a transitional phrase. And the third one is a body of the claim, which I have highlighted in yellow. And remember, always remember one thing, a patent claim always reads only in one single sentence. If you can see, it has started from this writing apparatus, and there is only one period at the end. There is no period in between. So a patent claim always comprises of only one single sentence, which should be grammatical correct. So there is based on the like legal requirement, there is some style of writing which is needed to understand this special style of writing the patent claims. Otherwise, rest of the patent drafting I have mentioned in the patent anatomy, these are just you need to explain the complete storyline. But writing the patent claims needs some guidance, needs some expertise, which you can gain by doing some practice. So see, I have written just this an example. I have quoted this from the WIPO drafting manual. So it is related to a writing apparatus comprising a pencil having an elongated structure, including two ends and a center between the two ends. Eraser, a light. So by reading this, you can easily understand we are talking about a writing apparatus. So here we are trying to keep it broad because a writing apparatus could be a pen, pencil, marker, anything. But comprising means we are keeping it open-ended. We will talk about comprising and all the different transitional phrases in the subsequent slides. So this particular claim is having this preamble, transitional phrase, and these are the three elements. I have just like bullet marked it. So it is having a pencil, an eraser, and a light. And if you see, these are the like the components or elements of the writing apparatus. And after this pencil, if you see having an elongated, these are the like the special features or how these are interconnected. These three different elements are interconnected with each other. You must have to mention the interconnection of different elements with each other. If we are simply saying a writing apparatus comprising a pencil, eraser, and light, so we won't be able to achieve anything because we are not specifying where the eraser is attached or where the light is attached on the pencil, whether it is attached on the one end or in between or at the starting. So we must have to mention all the interconnection between different components, whichever like many different patent drafters try to they due to oversight or due to like inexperience try to like they used to forget, I would say, they because nobody intentionally avoids these things. So as Dr. Deepti has mentioned about the subject matter eligibility and patentability, we generally talk about only novelty and non-obviousness in the patentability requirements. But for drafting a patent application, these requirements falls under subject, I would say the subject matter eligibility, which in US falls under 35 USC 112 rejections. So these should be taken care of, how different elements are interconnected with each other so that no element should remain hanging in the air. For if we take example 2, we are talking about an apparatus for holding items comprising 4 legs, 16 screws, and a top. If we read this, what picture comes in our mind? A table which is having 4 legs, and 4 legs are connected to the top with 16 screws. This is my interpretation. There could be multiple interpretations for these. So in that way, one can write a patent application, and the scope of narrow and broadness will always depend on the choice of your words you are using, be it in the preamble or in the transitional phrase or in the body. So scope of the claim should be narrow enough to avoid the prior art, and it should be broad enough to avoid the design around. Design around is nothing but anybody can copy your idea without infringing it. So you must have to think from these two perspectives always while writing the patent claims. So this is a generic format of claiming: preamble, then transitional phrase, and then all the elements. And like see, preamble separated by a comma, then transitional phrase separated by this, and then elements are separated by the semicolons, and in the last there is a full stop. So every like patent claim is only a single sentence, grammatically correct. So if we have to like in practice, but how we use it, an apparatus, this is a preamble comprising is a transitional phrase, and 1, 2, 3 elements are a plurality of pages, a binding, a cover. So these are the elements, and This is how these elements are interconnected with each other to give you a complete picture. Not only you, to a person having ordinary skill in the art. So a plurality of printed pages, a binding configured to hold the printed pages together, and a cover attached to the binding. So after reading this, you can interpret it either as a notebook or a journal book we used to read. It could be anything. So this is how a patent claim looks like. These are very generic and simple example. For any technology, you can write down your claims, but format will always remain the same. And it doesn't vary hugely for the different jurisdictions, but there might be very minute or slight modifications from one jurisdiction to another, but the overall structure and the requirement always remains the same. Suppose for this one, if we are talking about just the preamble, it should also be concise. If one needed, they can keep it broad, but if one has a specific purpose of the invention, they can specify it clearly in the preamble, like an apparatus for cooking, a method for making tea, or a device for mounting a telephone. So it must clearly give the demonstrate the intentions one is trying to achieve from that patent claims.
Hello,
If you
Rakesh.
want to find, yes, please.
Please, you have about 3 minutes, please.
Okay.
Since we'll still be talking about claims next week, because the main topic for next week is claims, so we can dive deeper into claims from next week. Thank you so much.
So from that part, like the format of claiming is there, and the anatomy is also there. So based on that only, we will talk about these in the next section about the how broad and narrow claiming we can achieve and on what basis. We will talk about these in the next session. So there are like multiple advantages or feature, I would say, for different jurisdictions, which we call independent claims and dependent claims. So independent claims are the first claim of an invention, and dependent claims are there, which are specifying the additional limitations of the independent claims, which we will be going to discuss in our next session. So this is how a patent claim looks like, and these are some kind of like amendments we have made. This is an independent claim, or it is a dependent claim, which is depending on the independent. So like in summary, if I have to tell you about the today's session, just not only just focus on the claims now, because we will be discussing about this in the like next session, but define the claim terms and everything, whatever you are trying to claim, define each and everything through your drawings and through your detailed description, and do not write any solution part in the background section. So these are the like pointers you must always remember while drafting a patent application. Rest of the things will come with practice. Thanks. That's all from my side.
Thank you very much, Rakesh, for that detailed presentation. What I'm very sure of is by the time we start getting people or companies reach out to us to help draft, we can come back to watch these videos again to guide us on how to draft our patent and also draft our claims. Thank you so much. So we'll just be going straight into the questions and answers. And we have four questions. So we'll ask the first question to Dr. Depti, the second question to Rakesh, the third question to Dr. Depti, and the fourth question to Rakesh. So the first question to Dr. Dipti is, in detail, what is inventorship? What is inventorship? So we have about 2 to 3 minutes to answer the questions. So this is for Dr. Rakesh. What is inventorship?
Inventorship is nothing but the rights given to the inventors for their own patent. and they transfer their inventorship to the assignee or the company they are working with, in very simple terms.
Thank you very much, Rakesh. So we'll ask the next question to Dr. Dipti.
May I just add something to that?
Yes, please. Yes.
So the way I understand it, an inventor would be a person who technically basically works on the invention. It's very important that there should be a technical contribution. So inventorship really directly relates to the claim. So an inventor is a person who contributes actively to the conception of the invention and contributes to the claims of the invention. So a person who does not contribute to the technical side or the claim of the invention cannot be considered an inventor, because it's a detailed description, as the student has asked. So a person who had no part in the research, regardless of the fact that they funded or were the supervisor in the company doing the invention, they won't be considered the inventor. An inventor or a co-inventor has to be a person who has contributed to the entire conception of the invention, the technical aspect of the invention, which is then related to the claim of the invention. So inventorship basically relates directly to the claims of the patent application.
Wow, that's a very beautiful explanation, and it's easy to understand. Thank you so much, Rakesh and Dr. Dipti. So the second question is for Dr. Dipti. What are the benefits of filing a provisional patent application? What are the benefits of filing a provisional patent application? About 2 to 3 minutes. Thank you.
Certainly. Thank you again. And I'd like to ask Rakesh to add in, because that really helps as mentors to help the mentees. So the benefits of a provisional patent application, like was said very first in Michael's presentation, it's like a placeholder. So as you may understand that there is the aspect of novelty, which is checked from the date of filing. So the very first filing or becomes the effective filing date or the priority date for the filing of an application. And that comes from the provisional patent application. So there is that benefit. But then there is also the benefit from the filing of the provisional patent application, because you're not disclosing any claims. You're not really binding your information that you're disclosing to the patent office in terms of the claims. So there you're adding the advantage that you can basically disclose the idea per se at this time, not defining the boundaries of the claim that you're going with. So that way it gives you some flexibility in redefining narrower though from the idea that you've disclosed in the patent provisional patent application in terms of what you are going to claim in the complete or the final patent application. So that allows you some flexibility, I'll use that word again, so that you can do your respective experimental studies and see whether the idea that you had proposed in the provisional patent application, whether that pans out to the whole degree that you had thought of, or whether there are certain aspects that better better define the idea of your invention in terms of the scope of the claim. Like Rakesh was saying, it is the scope of the claim that is very important. So that is where a provisional patent application, where you're just giving the idea, may help you, because you've not done the experiments at that stage, so that you can do the experiments and see whether the particular invention and the kinds of invention that you have provided, which may work best when you're going for the final or the complete patent application. So that's second. Thirdly, after the provisional patent application, what you can also do is go for a international, so if you wanted to go for different jurisdiction, so you can go for a convention application or a what is called a patent cooperation treaty application, an international application. So within the 12 months where you would have gone only in your own jurisdiction with a complete application or a complete specification filing, you can go for a convention or a PCT application. And by doing so, what you're doing is you are claiming for multiple jurisdictions through that route. So those are some of the important. And then, okay, there's one more advantage, that because provisional patent applications are not published, so you can always withdraw your application quite easily at that stage. So those are four benefits that come to my mind, but Rakesh, please feel free to add.
Thanks, Deepti, for this wonderful explanation. So in my viewpoint, like you have covered maximum pointers. So I would also simply say, except Ayurveda, everything must be having like disadvantages. So like provisional is having multiple advantages, like it helps you in securing or anchoring the priority date from where nobody can steal your idea. It helps you like giving or a like timeline where you can do experimentation and try to like file some other modification or enhancement to your invention. But on the contrary side, it is having some kind of like drawbacks also. Suppose you are filing a provisional with very little or less disclosure, and at the time of filing a non-disclosure, like non-provisional or complete specification, you are expanding it to a certain extent which is not supported by the provisional. So that could be a drawback at that time. So while filing a provisional application, if you are able to capture the broader idea in your mind and you are trying to secure a priority date, then it is advantageous. But if your idea is not mature enough and you are trying to secure a priority date, and after that date, your idea, you are trying to expand it even more level, then you are not entitled to get the benefit of that provisional date or priority date. So always think from both perspectives. If you are like dead sure or 100% sure whether your idea you are trying to conceive into patent invention or you are trying to develop it into some kind of product, always try to cover the broader picture or broader perspectives in terms of the provisional application, because that broader aspect cannot be expanded beyond that limit in the non-provisional patent application, which like you are giving or getting a timeline of 12 months. So always try to protect the broader picture in your mind. So this is the only recommendation as a patent professional. While filing a provisional application, just try to capture the broader picture in their mind, because there are multiple case laws also which I would like to share with each and everyone, but not at this time because of the scarcity of time, and request Juliana to move to the next question.
Thank you very much, Rakesh. Thank you, Dr.
Thanks.
Dipti, for talking about the non-provisional patents, the advantages and the disadvantages also. So I'll just move to the next question. After a non-disclosure agreement is established between a patent drafter and the applicant in the presence of the representatives of the applicant, supposedly one of the representatives of the applicant discloses any part of the invention publicly without prior knowledge of the applicant, will that also be called a patent infringement? So this question is for for Rakesh, sorry. So after a non-disclosure agreement is established between a patent drafter and the applicant in the presence of the representative of the applicant, supposedly one of the representatives of the applicant discloses any part of the invention publicly without prior knowledge of the applicant, would that also be called a patent infringement?
So like in my viewpoint, in US, I am like pretty sure as per the law, there are multiple exceptions where this won't be treated either as a patent infringement, but as a prior art also. Suppose any of the representative or like with whom we have signed a contract or any of our co-inventor has disclosed our patent invention or idea in the public domain without filing the invention. So like there is a timeline in US, we call it a grace period of 12 months. So for that, it won't be treated as a prior art, not the patent infringement simply. But for other jurisdictions, laws are strict. For example, the Europe, it could be treated as like a prior art against your invention, or it could be a subject of the law, which I am not very much sure. But Deepti, if you can touch upon this point, it would be much more helpful for everyone.
That is a good question. So when you are thinking of a non-disclosure agreement, wherein a person who's present and without prior knowledge, like Rakesh was saying, that is very, very critical, that it is done without the prior knowledge. Now, patent infringement, as I understand it, it very much correlates with what is a right of a patentee and what is it that that monopolizes, or what is it that a patentee can exclude the other person from doing. So that is like the making, the selling, the use, the import, and all of those things which are included in what a grant of a patent would do. Whereas if there is just a disclosure um, that is done by the scenario that is provided to us, I don't believe that really comes within the confines of patent infringement, like Rakesh was also saying. That's very much related to the prior art, it becoming a prior art. But then again, like he said, there are means to overcome that in different jurisdictions. So there is a grace period which is allowed for filing of the application that an applicant can use in that period. Or there are means that they can establish that this was done by fraud in various jurisdictions. That is also allowed. So it is very jurisdictional that you will get an answer to this question. But overall, whether it will be considered a patent infringement, in my understanding, it is not patent infringement.
Thank you very much, Dr. Deepti. Thank you, Rakesh. So our final question for today is for Dr. Deepti, and I'm sure that Rakesh can also touch on it. What happens when a patent expires? What happens when a patent expires?
So when a patent expires, it enters the public domain. That is the whole point of this contract with the state that you are establishing. That you're basically establishing a contract for your disclosure with the country that is granting you that right in terms of a patent. So when it is expired, which is generally the 20-year time period, it enters the public domain and it is available. But one thing that one has to still consider, still have to take into consideration, is the aspect of in the market what happens. So there is the freedom to operate that one has to look into. Even though a patent has expired, whether there are sister patents or daughter patents, whether they have produced other patents which are correlated with the first patent. So that is something one has to take into consideration. Many of the jurisdiction, on the other hand, also inhibit or prohibit what is called the evergreening of patents. So that is another aspect one has to look into. So again, this becomes a jurisdictional perspective is very important on this idea. When the patent expires, does it truly expire? Because in many of the other jurisdictions, they may have a follow-up patent, which would be a concern that one has to look into. But otherwise, it enters the public domain. Rakesh.
Thank you very much, Dr. Deepti. Yes, over to you, Rakesh.
No, I echo with Deepti on the same, like if it is expiring, it is getting into the public domain. Anybody can exploit it, be it a like method or a process. They can start making, using, manufacturing or selling it or importing it. Nobody can come after them for charging for the royalty or any kind of infringement perspective.
Thank you very much, Rakesh, for that answer. And thank you also, Dr. Deepti, for touching on the evergreen patent stuff that people do to ensure that their patent keeps living. And I'm sure that Michael has taken note of it and that he'll also read up on that. Thank you so much for today. It has been an amazing time listening to Dr. DP and to Rakesh. Thank you so much. We have learned a lot about drafting of patents and the different treaties that apply. Thank you, Michael, for your presentation. Beautiful presentation, beautiful research, and beautiful smile while you were presenting it. Thank you also, Hussein, for moderating the session today. Thank you so much for working on the admin stuff. Thank you, Joseph. Thank you, everyone who has made this a success. Please know that the video for today's session is on YouTube. So if you want to go back and watch it, you can still do that so that you understand it better. And if you want to practice, please practice. And then if you need to send your practice to any of the mentors, please let us know and we'll reach out to them so that they can go through what you've tried to draft. So with that, we've come to the end of the session for today. It's an amazing time we've had today. Thank you, Dr. Deepti. Thank you, Rakesh. Thank you for answering our call. We are so grateful. Thank you for pouring into the next generation in Africa. Thank you so much and have an amazing time. Bye.
Thank you, Juliana. I must say thank you, Juliana, Hussein, and everybody for organizing this. And Michael, a great job. Michael, a great job.
Thank you.
Thank you. Bye.
Bye.
Bye, everyone.